Good morning, I'm Kenny Gale, and I am the branch president for the Charleston branch of NAACP. I thought I was going to have 30 minutes, it's been short, dropped to 20, so I will try to be quick, short, to the point.
We can run over if you need.
Okay, well, yeah, first I want to talk about the history. Then I want to talk about the Human Rights Act, West Virginia Human Rights Act itself. And then there were some handouts you were given from 2004 to 2010, those annual reports on, that's the main focus and substance I did want to talk about. Quickly, the history. For this august body, the legislative body, in 1921, developed what was then the Bureau of Statistics, Negro Statistics and Welfare. And that mission of that office was basically to keep statistical data on African Americans, as we call them now, the Negroes of West Virginia. The reason they created that august body decided that is because during that time frame, early 1920s, late 1919 time frame, there had been some riots because when soldiers came back from World War I, African American soldiers had been lynched, and there was an increase in the labor market in the West Virginia coal industry, and they didn't want this same type of attitude to prevail coming into West Virginia, so they created this body, this Negro Commission. Dr. Hobson, dentist from Charleston West Side, was probably a director for a long time. He kept these statistics up until 1954. Very historic year. That was when Brown versus Board of Education. So there was a sudden change. The commission sort of slid to the sunset. And again, as Mr. Mall said, 50 years ago, in 1961, the Human Rights Commission was formed. All right. Quick history. There's more history in your archives over at the Science and Cultural Center. Very, very informative information. And in fact, you can tell from the information he gathered, whether where the black barbers or dentists or where in every city and state, so we get accurate stats on the businesses. But your Chapter 5, Article 11, the Human Rights Commission, and the -1 short title is the West Virginia Human Rights Act. I want to quickly talk about the declaration of the policy. It's the public policy of the state of West Virginia to provide all citizens equal opportunity for employment, equal access to places of public accommodation, and equal opportunity to sell, purchase, lease, rental, and financing of housing accommodations for real property. This equal opportunity areas of employment and public accommodations is hereby declared to be a human right or civil right of all persons without regard to race, religion, color, national origin, ancestry, sex, age, blindness, or disability. Equal opportunity in housing accommodations or real property is hereby declared to be a human right or civil right of all persons without regard to the same. The denial of these rights to properly qualified persons, reasons of race, religion, color, national origin, ancestry, sex, age, blindness, disability, or familiar status is contrary to principles of freedom and equality of opportunity and constructive to a free and democratic society. I read that policy because of the very nature of this policy 50 years ago had a wide basis and a wide variety. The other thing I wanted to point out in the Human Rights Act law, that I did not give this it's not a test, you won't be tested on it, but the Human Rights Act is out there on your website, so you can look up any time. But what I wanted to bring out in particular were the power and objectives of the commission itself. Because it seems right now we're even out of compliance, we say in the federal side, because under 5-11-6 says commission organizational personnel, executive director, offices, meetings, quorums, expenses of personnel. As soon as practical, after the first day of July of each year, the governor shall call a meeting of the commission to be convened at the state capitol. The commission shall, at such meeting, organize by electing one of its members as chairperson of the commission and one as vice chair thereof for the term of 1 year until successors are elected and qualified. At such meeting, the commission shall elect from its membership such other officers as may be found necessary and proper for the effective organization. And the reason I want to go into the law is because if you don't know the law, you don't know how you're supposed to act. But right now, like I said, I don't think the governor is in compliance because he is not, it shouldn't be and there's an acting appointing director, and that person should be appointed. When you get out of compliance, laws can be broken. And the other thing I wanted to point out that the commission, or the purpose of the commission was the fact, if I can find it real quick, yes. To recommend, one of the things, okay, I'm back up real quick. The powers of the commission and the way it was organized was to allow this body, the Human Rights Commission, to recommend to the governor and legislative policies, procedures, practices, and legislation in matters and questions affecting human rights. Also, now, there's another legislative process here. Oh, to create such advisory agencies, conciliation councils, local, regional, statewide, as its judgment aid in effectuating the purposes of this article, study the problems of discrimination in all specific fields and instances of discrimination because of race, color, religion, national origin, ancestry, sex, age, lines, disability, or familiar status, and to foster community effort, otherwise, goodwill, cooperation, and conciliation among the groups and elements of the population. Well, in reading this, there was a lot of power that was given to the commission. And it seems, and historically, this power has been delegated or allowed to be assumed by the executive director. Now, I'm not faulting the executive director. Somebody's going to give me more power, I want to accept it too. But I think it was the power of the commission, not the power of the executive director. And the one thing I wanted to point out, historically, it mentions it also in this act, that the commission would meet on the second Thursday of each month. And I remember historically going to some of those meetings as the state president of NAACP. Well, for some strange reason, this past year, the commission did not meet once. Look into it, look at the minutes, there are none. The commission never met. So these commissioners, even those who couldn't make it, will even telephone in to this. So this body's not meeting. And they are by law required to meet. And then something, again, the law's being broken. And now we will get into the facts. Again, I think to brush myself off, try to slow down. And I tend to talk fast anyway. So I apologize for my inculturation. First letter that I handed out was Governor Wise's letter, and it shows the executive lead being Ms. Ivan Lee, and she states her vision, and behind that you'll see a 3-year history of complaints filed by the protected class. I'm sorry that we couldn't give you color copies so you see different race, disability, sex, age, religion, ancestry, national origin, lines, and familiar status, but you can see at that point in time, most of the cases filed between 2002 through 2004 were race. That's the thing I wanted to point out. The other thing I wanted to point out is there was a sudden change if you look at 2005. There should be a letter prior to that, and that's the one you said, the early dispute resolution package. There's again a letter by the Honorable signed sending to the Honorable Joe Manchin by the Executive Director. Behind that is the role of the commissioners. And the role of the commissioners is to set policy for commission, act as an appellate body, approve modifications and amendments, have an awareness of civil rights issues, be visible in communities, provide assistance and information, form advisory committees, attend monthly meetings, as I said earlier, and receive ongoing training from staff of the Human Rights Commission. Okay. The early dispute resolution program, if you look at that, there's some, it's articulated very well for things that will happen, predetermined conciliation, what that involves, what all it dealt with, cases, and even the monetary settlement amounts. Okay, that's just predetermination. And it talks about what they do on a non-monetary settlements. After that, it talks about the mediation program. Now, I can tell you, being a federal employee, the mediation program is highly recommended. Administrative law judges, even if it gets to them, they're going to recommend you go back and try to mediate with alternative dispute resolution processes. Those are set up to resolve the issue at the lowest level through a third party. But there's actually not, I guess at this time, there were no complaints resolved through mediation. Well, yes, there was. I apologize. On the very next page, settlements that went through mediation, over $1 million worth of settlements that were solved through the mediation process. And then the intake process, again, over 1,800 intakes. They were broken down by month, where the telephone walk-in and mail, the complaints that were filed. And again, there is, at this point in time, articulated in the report whether these were disability, race, all the way through ancestry and national origin, and even in the month they were filed, which was whether they were employment, public accommodation, housing, and total complaints filed. So I thought this would be a very thorough report. And from a NAACP and perspective, this is the type of report we thought we would continue to see. And then you have the next 5 years worth of reports, or 6 years of it is. Beginning with, again, the letter from from item E, the role of commissioners, and then the facts and figures. And I've kind of rolled that backwards from 2010 to 2006 and 7. And what I wanted to point out is now the total walk-ins, again, remember in 2005 it was 1,800, now the total walk-ins is 1,217. The other thing I wanted to point out is the probable cause, and this is a term that the Human Rights Commission uses, whether a complaint is filed, whether it has a probable cause or no probable cause. And over 90% of complaints filed, over 90% of the complaints filed to the Human Rights Commission had no probable cause. No probable cause. The other thing I wanted to point out was the monetary impact. The monetary impact. Things that went through conciliation, the average complaints and the result of them, non-complaints, $44,000. That means complaining who went through the conciliation process and mediation process, basically, for those non-complaints, got about $5,000. Yet if they went through the mediation process, the 21 cases that were settled, averaged about $27,000. So which avenue would you choose if you were going to go to the Human Rights Commission? It becomes a dollar figure for the complainant, and that's what they're going to start to look at. Why do I bring this up? The NLCP has long been an outstanding proponent and partner even with the Human Rights Commission. A lot of complainants, individuals come to our agency or to our organization and ask for help, seek help in elucidating or clarifying their issues before they present their case. And I even had a comment from one complainant, and that they were told by the Human Rights Commission that they need to go see the NLCP first. And that has not been the order of business. We are just an agency that tries to partner with the Human Rights Commission, but we don't take effect. We do not have the capability, nor are we staffed. We're a volunteer organization. Only our national office has people who are on paid citizen positions, and they got four legal appointees, two paralegals and 2 lawyers actually work for the whole national organization, and they're over 350,000 strong. So there's no way they can cover all the cases that come between the Human Rights Commissions in each state and on the national level. In other words,